Good afternoon, Judge is it Ratshibvumo? Vumo?
Sure.
Don't laugh at me.
Good afternoon, Chief Justice, and good afternoon, all the commissioners.
Okay. How are you this afternoon?
I am doing fine, Chief Justice. How are you doing?
I'm fine, thanks.
Thank
Just looking forward to this interview.
Thank you.
You hold 3 law degrees, 2 from the University of Venda, a BUris and LLB, and an LLM in international law from the University of Johannesburg.
Yes, I do.
Okay. You were a public prosecutor at the very beginning of your legal career.
Yes, I was Chief Justice.
Since which year?
Started in 1996.
And how long did you remain in that office?
I remained public prosecutor until 2000 when I was elevated to the office of a magistrate.
Yeah. And you rose through the ranks of that rank of the judiciary to
Yes,
become
I did.
a regional magistrate.
Yes, I did, Chief Justice.
And that was in 2009?
Yes,
And you were a regional magistrate until 2021.
yes.
How many years is that? It's a long time.
That was indeed a long time, from
Yeah.
2000 until 2021. I think that's about 21
11
years.
years. And you had started acting as a judge periodically since 2013.
Yes,
And you acted right through until 2021.
yes, I did, Chief Justice.
And it's intermittent stints.
Beg your pardon?
I'm saying it's intermittent stints, a
Exactly.
number of stints. Just give me the arithmetic, mine is bad. How long was this entire stint in all?
It must be in the region of, because I was acting almost like a term almost every year
Yeah.
since 2013, just over 2 years or so.
Yeah. Okay. And you were finally appointed permanently in July 2021.
Yes,
Okay. So all right. Still doing my math. And you've had the opportunity to act as the Deputy Judge President in that division
yes, I have. I think from September 2023.
from 21 August, you say in your questionnaire.
Oh, that would be accurate, yes.
Yes, that's almost a year. Well, that's over a year. We're in October, I forgot.
Yeah, that's over a year, but I need to indicate, Chief Justice, that I wasn't acting throughout. I would act, and then someone would act. I think I interchanged with 2 other judges. At one
All
stage,
right.
it would be Judge Mashile. There was also Judge Hwele.
So this was done on a rotational basis.
Yeah, it was something like that, because we would alternate in a way.
Okay. And what kind of duties have you performed in your position as acting DJP?
I think I did everything that the JP will do. You name the case allocation to other judges, presiding over the PEEC. The judge president also introduced something, the REEC, that is on a regional level. I also took part in those meetings. I chaired them, and even when I wouldn't be acting out of interest, I asked and was invited to attend those meetings, even when it would be another judge who's acting as DJP. So I did almost everything that DJP will do. Chaired the meetings, took care, interacted with the stakeholders, the community out there. When there will be problems, from time to time, there will be members of public who have issues with anything in the court or any of the support staff. And on several occasions, the JP will delegate and mandate me to interact, and of course, under his supervision, also come up with resolutions in interacting with those stakeholders. So I did quite a lot during the period. Any other task that she mandated me, I took care of it.
All right. Just to retrace my steps, I forgot a tiny but very important detail. Your LLM you passed with honors. I'm sorry I didn't mention that. I know it matters to people because they've worked hard for it. So your LLM, you passed cum laude.
Oh, yes, I did,
Yeah.
Chief Justice.
Okay.
Back then, cum laude, and I was also awarded a gold medal for being the best student at the time at UJ.
Okay. You've been a judge in essence since 2013, so you've had an opportunity to produce many judgments, which I hope you've done.
Yes, I did.
How many?
213 judgments.
Any of them reported?
Definitely, total of 10.
All right. And you would have sat in all the courts you find in the High Court, I imagine. Your
No, I
trial
did,
court, appeal court.
Yeah, I did, Chief Justice, yes.
Okay. Just just give me a bird's eye survey of the kind of cases in which you've said. Or maybe let me say you have not said.
No, I think currently you can call it, I've been an all-rounder, I think I can say. I mean, after my appointment on permanent basis, in fact, starting from when I was acting, I hardly did criminal work. I suppose the JPs at the time, starting with JP Mlambo, who first recognized me here in Gauteng, the JP Likhodi, and now JP Mpatlele. They must have realized that I have a strong background in the criminal law. So almost all the judgments that I will be referring to that I'm saying I've written, or more than 90% of them, they are in civil law, and I've said in various different kind of cases, and I can say confidently I've been an all-rounder currently, Chief Justice.
You mentioned that you've been involved in training with Sajay and UNISA, but you don't specify who you trained and in what areas of I imagine it's areas of the law.
Right.
Was the training of magistrates and other judges?
Yes, I did take part in the training mainly of the newly appointed regional magistrates, newly appointed magistrates, that is with Sajay. And with UNISA, it's a department called Chance to Advance. What we will do, or what UNISA does, is they identify some rural community out there which needs some assistance, and they will invite me to be part of their panel, talking to members of community, and they'll say to them, come listen to Judge Takalani, and we will be talking on various issues of the law. And they allowed me an opportunity to choose the topics that we'll be talking about. And I, for one, for reason that I've been involved in the community service, community work for many years, I've always preferred to talk about topics such as maintenance, domestic violence, recognition of customary marriages, because most of these people you find, they are married, lobola has been paid, but they are not fully aware of their rights as people who have been married traditionally. That, for example, person cannot just come back home and say, out of my house, when he has paid lobola. They are the co-owners of those homes. So those are the kind of topics that I'll be talking to them about. And once we are done, UNISA will give them certificates to confirm that they attended the training course, and it will help them in one way or another. It's called Chance to Advance.
Well, you say you've also participated in the training of personnel in your court itself now on how to conduct legal research, and you are part of the library committee.
Yes, Chief Justice, what happened is we were trying to talk to the challenges of shortage of staff. I raised this with our judge president. We don't have enough personnel. I mean, in Mpumalanga, we have only 2 law researchers, one in the main seat, Mbombela, and another in Middleburg. Currently, it's even worse because the law researcher for Mbombela is now acting as a chief registrar in Middleburg. So with this shortage of staff, I made a proposal to the judge president, and she liked the idea that we should train the staff. We should do with what the legal that we have. And we did have a day in Mbombela, and then all the staff members, the secretaries, the registrars, and all the chief registrars from Middleburg and Mbombela, from around 9 a.m. until 4 that day, I was training them how to do law research, and I was making use of my expertise in a way. You will see that I also hold 2 IT qualifications. I'm a member of Judge Committee that is chaired by Judge President Mlambo. So those qualifications in IT, they come in very handy when I have to do research. It's no wonder my first reported judgment is a case that came in 2013 when I acted for the very first time. And by the way, I also took part, I was part of the delegation that was on a study tour to Washington, D.C., under the leadership of Museneke DCJ at the time. President Molomela was part of that delegation, and it was a study tour on e-filing. And so that information came in very handy to Judge Committee. So when you train people how to do research, be it on JUTA, be it on LexisNexis, and even Safely, they find it very handy. And I can just say it in the words of one of those who attended the training, who said, "I wish I got this information before I could complete my LLB. Who knows, maybe I would also have completed with cum laude like you, Judge." Yeah. So that's what we did.
So you were involved with the project of court digitization from inception?
I was. In fact, that predates my appointment as a judge, Chief Justice. When it was rolled out as a case line for the very first time, I was on the very forefront with the JP and other members of JIDE, training the judges in how case line works. And when that time comes that a cotton line is rolled out to Mpumalanga, I will be ready to play my part in training my colleagues in Mpumalanga, as I'm already doing right now. By the way, when we were in 2020, and we had to do a lot of work virtually because of that virus, I was very much in the forefront of helping my colleagues how these things operate. And we were successful, and I do hope that we will be successful when that time comes for the rollout.
Okay. Why have you not mentioned your IT qualification in your questionnaire? Because it is relevant.
Chief Justice, if I didn't mention it in the questionnaire, maybe I didn't spot where it would fit. But
along with your other qualifications?
I think I did, Chief Justice.
No, you didn't. It's
but it is in my CV, which accompanied that questionnaire. It is in my CV. All
right. You've also conducted training of magistrates through JOASA as well.
Yes. I was in the leadership of JOASA for quite many years. I was its deputy president for 2 terms. I also became its president for another 2 terms. We will conduct training in various topics. Maybe to start it a little backward in JOASA, From the early years when I was only a secretary, a provincial secretary, because I was in the leadership of the executive of JUASA for over 10 years. In those early days, I would send a communication maybe twice a week titled Matters of Interest to Judicial Officers. In those emails, I would be sending or summarizing judgments of importance that may have been delivered by the Supreme Court of Appeal, the Constitutional Court, or even other higher courts, as long as the judgments impact on judicial officers, hence the topic. And I will try and summarize those judgments in only one paragraph. You know, judicial officers sometimes don't have time to go through all the information or lengthy judgments, especially the kind of judgments delivered from the Constitutional Court, which are usually very long. So I will summarize in one, sometimes just two judgments, two paragraphs, what the judgment is about, and send that. And over the years, even when I was president of JUASA, I was still doing that. I think the emails that I sent could total more than 200. So all those emails, they are part of what I gave even to the personnel, the support staff we were talking about when I trained them. That whole training doesn't just involve me showing them how to do training. I also gave them about 10 gig of information in a memory stick. Inside there are many case law. They're able to get all the cases, in fact, the law reports, even when they are offline. So I availed that information. That folder is called, or they will refer to it as TV package. So I did a lot of training as peer training for magistrates, regional magistrates, and sometimes we'll get some funding from various corners to see to it that we are able to do training. And the reason why we started training, it predates the days of Sajay. Shortly after the days of Justice College, we realized that there was a lacuna, and we stepped in as JUASA, and we did that training, and it was successful.
You have furnished us with a comprehensive vision that you have for the court, and I'm assuming that it dovetails with what Judge President Mphahlele has in mind for that division. Is my assumption correct?
No, definitely. I talk to the Judge President from time to time. We share the ideas. Whenever I have something to propose, I'm the kind of a person, Chief Justice, who I do not wait for problem or suggestions to come my way. I will approach. I will get to you and tell you, I have the following proposal for you. Maybe, by the way, I can just say the following on a lighter note, truthful as it may be. It was yesterday when I received a call from one of the secretariat here informing me that I may send the slide by email, that I made a proposal. That's the kind of a person I am. I said, hey, I was expecting your call to tell me that the time, the schedule for the interview would have changed. And she asked me, what are you talking about? I said, there's a candidate who was going to take the whole 40 minutes, but he withdrew. Why didn't you tell us that we would have to be here 40 minutes earlier? She said, oh, I forgot. Thank you for letting me know. And she immediately, at my suggestion, sent the email, not just to me, but to all the other candidates that schedule has changed. It will be 40 minutes earlier. It's going to work that way. And as a result, I thought I would have been here much, much earlier. Unfortunately, it's back to square one. Yes. But yes, Chief Justice.
That's how these things work sometimes, most times.
I did share my ideas, everything that you see here. The Judge President is aware, and where she was happy with some of the proposal, she created the committees, and she put me to be in charge of those committees to run with the vision.
All right. Okay. And I'm going to say to you what you say to counsel in court, that you can be assured that we've read your vision, or their heads of court, their heads of argument in their case. So you don't have to take us through everything. I just want you, if there are any items in this document that you think are worth highlighting, just bring those to our attention, the banning issues, just briefly.
I appreciate that, Chief Justice. I will do exactly that, and I also had that in mind that I may not have to go through all the slides, so there are just few aspects or pointers that I thought I may run through. And like I indicated, the division has only one judge president. Ours, as the judges in the division, is to stand behind the judge president. If we have any vision, like I've indicated, there are other ideas that I had, and I still have. Ours is to sell our vision to the judge president, and if she is happy with that, then that becomes the vision of the judge president, and as the judges in the division, we have to run with that as our own vision. And that's what I've been doing. And luckily, our judge president is accessible, willing to listen, and you will never be turned back if you come with the ideas. In fact, you will be told to run with those ideas, as long as she is convinced that it is in the best interest of the division. I have had an opportunity to talk to the JP to inquire what her vision is. And the moment, of course, I was told I would be acting as DJP, I took it upon myself to find what her vision is. Not only through talking to her, I watched her interview when she appeared before this body, when she was asked about her vision. I went through that vision, searching to find out what is it that I can take from her vision to run with, because my belief is that as judicial officers, as judges in the province, we are called to serve the people of Mpumalanga. And when I got those ideas, I was able to find that her vision, the priority has to do with service delivery to be taken to the public, speedy finalization of the cases or trials, reducing a number of awaiting trial prisoners, harmonizing the judicial oversight and responsibility over all courts, that is the high courts, regional courts, and the district court. We were able to, I was able to establish that she wants to have all reserved judgments kept to under 3 months. I had to come up with ideas on what proposals I have to see to it that no judge in our division would have judgments reserved for longer than 3 months. Maintaining the cordial relationship with the legal practitioners, the professional bodies, and other judicial officers through the hierarchy, meaning in the regional courts and the district court. The challenges that I was able to pick up, luckily I had the opportunity to sit in the REEC like I've indicated. I also had the opportunity to sit and chair the PEEC over the past 12 months, and from these I was able to pick up a lot of challenges. He had the opportunity to engage with various stakeholders in the division. He had an opportunity to interact with the provincial executive and the legislature in Mpumalanga. And from these, one is able to pick up a lot of things. I was also been given an opportunity to engage with them like I just indicated earlier. I'm not going to stay much on this one. We talked about the judicial training, the training for the staff. She put me to be the chair of the committee, being Judicial Training Committee. And this is not only about staff training, but peer training. And in doing so, she was recognizing many of the positions that I served in the past. You would have seen that I indicated it's also on my CV. I was also the editor-in-chief of the Judicial Newsletter, which is spearheaded by Sajay. dealing with the training of newly appointed judicial officer. I'm not going to talk more of my role with Eunice a chance to advance. I think we covered that. And she also recognized the role that I played in talking, doing some talk show, which I did, more than 100 of them. I think it could be over 150 with the SABC and radio stations back then as a magistrate, which I did, of course, with the permission by the Magistrate Commission, which, by the way, I also served for several years as a commissioner. I also don't have any doubt that when she appointed me to be in the appointment committee, that's the committee that the recruitment committee in the division under HR, I represent the judiciary there. She must have been recognizing my role, having served as a commissioner and having served in many other committees, which I elaborated in the questionnaire and in the CV. And it has been working well up until now. I'm also serving in this came, of course, as a way to try and keep the challenges, the most important challenge, which is a great concern that affect the numbers of judges in Mpumalanga. There is a committee chaired by Judge Mashile that deals with the appointment of acting judges. I am part of that committee too. And number of ideas that I had raised with her, I am able to put through that committee. I've already indicated my membership of Judge, which I think will come in very handy when Court Online is rolled out finally to Mpumalanga. By the way, I'm also a chair of the library committee, and my membership of this committee or chairmanship predates even her time as the judge president, because I was appointed the moment I became a judge in that division. And as a result, I am able to tell you the challenges that we have as a division when it comes to library. I elaborated so much in my presentation. I don't think I will get to that, but what I can simply indicate in respect of this is that we are having a serious shortage of books, but I played my part using my IT knowledge. I can also inform you that all the judges in the division have access to a number of books, no less than 200. That is electronic books. When you talk of, like, for example, your criminal procedure, the rules, all the judges in the division of Mpumalanga, they are able to access that on their cell phones or their laptops immediately. Thanks to me having done that, and I thank the JP for having given me the opportunity to avail that to all the judges in the division, because that makes service delivery to our people much easier. Chief Justice, in this other slide, slide number 11, I elaborated all the challenges that I have gathered for the division. If I can read them, since like I indicated, I won't be able to go through them, but maybe just two, which I regard important.
Yes.
That's the inadequate number of judges for that division. Infrastructure challenges. Mpumalanga does not have a psychiatric institution, and that is a very challenging situation, because from time to time, Chief Justice, we have to make orders to refer the accused appearing before us in terms of Section 77 of the Criminal Procedure Act for mental observation. And what has been happening all along, the observations were taking place at the hospital wing of the correctional facilities, the prisons. Up until, I think it was in 2020, that I penned down a judgment wherein I indicated this is not in line with the provisions of the Criminal Procedure Act. It's not the lawful way of doing it. And since then, all the patients or all the accused who have to be observed, they have to rely on the neighboring provinces. That is your Gauteng, your Limpopo and the Northwest. And unfortunately, when they get there, the impression that I had when I was chairing the PEEC meeting is that they are being treated like stepchildren when they go to those provinces if they are having a bowel begging. Can't you just accommodate us? The
And
infrastructure
as I
challenge.
understand it, that challenge is not peculiar only to Mpumalanga. There are other provinces in the same position, and most unfortunately. But carry on, Judge.
No, definitely, that's what I also picked up. But I think in Mpumalanga, Chief Justice, we are hit worse, because in one of the meetings, I was very disturbed when I was informed that there was a patient waiting in prison for bed allocation for 5 years. And I felt this was totally unacceptable. This state patient is being treated worse than any other normal offender or sentenced prisoner. If this person was sentenced and given that 10 years imprisonment for the wrong that he committed, maybe in 5 years he will be out on parole. But this is an offender who cannot be sentenced because of his state of mind. He still has to find a bed as an involuntary healthcare user. Bed is not available, but he's staying in prison longer than he would have done if he had been sentenced. I found that we need to do far much more when it comes to this. An infrastructure challenge again in Middleburg High Court. No proper accommodation, and in fact, you will realize that the inspectors, I think I did talk to this, the inspectors from the Department of Labor, they declared the building of High Court as being occupational risk. And that, Chief Justice, is like a bomb ticking, waiting to explode. And I'm challenging everybody here, I can see even the Premier of the provinces here, that there is something that really needs to be done about that building. Infrastructure challenges also talk to lack of office space in various magistrates' courts offices, no running water, no electricity, and this, I'm not talking about load shedding, Chief Justice. I'm talking about the magistrate court in Akon Hook, which has not had electricity supply since 2022. They are relying on a generator which unfortunately can only provide electricity to the courtroom. All the other offices do not have power. We are talking of falling or leaking roof or ceiling. And this about the leaking roof or ceiling, what I've realized in this PEC meeting, you'll find it interesting. It affects all the court buildings, including our very own state-of-the-art Mbombela High Court, which was opened only about 4 years ago. It's leaking, and that wonderful furniture that was put in the building, it's damaged because of that roof or ceiling leakage of water.
Well, that problem is not peculiar to your court only. Many other courts, including the Supreme Court of Appeal and the Constitutional Court. So these problems are universal.
I wouldn't be surprised, hence I'm saying all the magistrates' courts in Mpumalanga, they came up with this challenge when it comes to roof or ceiling leakage. The inadequate support staff, at least I talked to this already, the high backlog, the awaiting trial detainees, and this one, it's also one that is very close to my heart, just like the lack of psychiatric institution. Because when it comes to awaiting trial detainees, you will find when you go further in my presentation that we do have awaiting trial detainees who have been waiting for their trials to be finalized for longer than 9 years, Chief Justice. Others, well, it will be 8 years, 7 years, and the like. This is unacceptable because at the time the trial is finally finalized, this accused will almost have spent his time in prison, served the sentence in question. The court online, I also talked to it about the state of readiness in Mpumalanga, that Mbombela is very much ready. Middleburg, I suppose it's also ready. Prior to that readiness, there was challenge with the Wi-Fi supply, the bandwidth supply being on a 5 gigabytes, and it had to be increased to 50 gigabytes, which has been done. And with that being done, I think in Mpumalanga, I can say, Judge President Mlambo, we are ready for that rollout. And of course, lastly, it should be the security in various magistrates' offices, easy access to offices of the magistrates, and not having the safes for the firearms at the entrance, at the security entrance. Having said that, Chief Justice, let me just talk to only one aspect of lack of, or rather inadequate number of judges and leave out the rest and just trust that the commissioners would have gone through this. When it comes to inadequate number of judges, you'll realize that Mpumalanga is the last born of the High Court Division, and it is born with this handicap that since its inception, it never had enough judges. It's not able to give service delivery to all the corners of the province. And as a result, it is not able to cater for what the High Court was able to do when it was under the division of Gauteng. The structure of the judges in Mpumalanga provides for 9 permanent judges, and that includes Judge President and Deputy Judge President. Cases that are registered in the civil roll from Mbombela and Middleburg. In 2023, we had in Mbombela 5,837. And this enrollment, Chief Justice, talks to about 486 cases that are enrolled per month if you were to give an average. And in Middleburg, this will be 5,257, about 438 per month. And that tells you that this is quite a lot. And as a result, okay, fine, right now in 2024, I need to bring this. By the end of September 2024, we were already sitting at 5,095 in Mbombela and 5,052 in Middleburg. This has gone up by 566 per month in Mbombela, 561 per month in Middleburg. We allocate 6 judges to civil court. That will be 3 in Mbombela and 3 in Middleburg. And if we are talking of only 8 judges, if we exclude the 9th position of the judge president, when you've given 6 judges to deal with the civil, you're left with only 2 judges that are going to allocate the rest of the work. Mpumalanga is a vast province. It relies on circuit courts for service delivery, that is justice to the people. And these circuit courts, maybe let's talk of the criminal court as a whole. There is a criminal court in Mbombela and 2 other circuit courts that will be Graskop and Barberton. But due to shortage of judges, the Barberton Circuit Court has been closed. And that court, Barberton, Chief Justice, is 42 kilometers from Mbombela. You look at Middleburg, there is a criminal court at the main center that is in Middleburg, but there is a circuit court in Brayton, a circuit court in Delmas. I may pause here to indicate that due to shortage of judges, the judge who's servicing Brayton, now it's also doing Delmas. It means you will do 1 week Delmas, another week Brayton. There is a circuit court, KwaMhlanga. This circuit court has been closed, but there is now a building structure and all preparation to have it reopened, and I know this is very close to the JP to have it reopened again, although it remains closed for now. And by the way, this is about 130 kilometers away from the main center, which is Middleburg. I still struggle to understand how she is going to win on this, but I'm trying to help putting the ideas putting our heads together as to how this is going to happen, to have Mpumalanga Court reopened, because this time it will not just be the circuit court, meaning the criminal court. She wants the issuing of civil matters there to be done so as to bring service delivery to the people. As a result, you will see from what I've indicated here, Middleburg needs 4 more judges, plus 3 from Mbombela. That makes it 7. But it doesn't end here, Chief Justice. It gets worse if you were to go down. We have Mkono, Peter Retief there, which is 239 kilometers. And this 239, I tried to calculate the closest part of Mkono to the seat of Middleburg. And I came up to these 239 kilometers. There is also a need to have the similar court to the people of Standerton. Standerton, again, 146 kilometers from the seat of Middleburg. If this was to be implemented, that means over and above those 7 judges, you need 2 more. That would be 9 judges. Unfortunately, this is not going to work. We only have 2 acting extra judges, 2 acting judges over and above the structure of 9 permanent judges, which have been working, and from time to time, we get indication from the minister, we want to withdraw it, it should work with the structure that we have.
Yeah.
And this is happening at the time while we want an increase. This increase, Chief Justice should also tell us, Mpumalanga population, the last time I did the calculation, it increased by far than any other province. And this increase, you'll get the statistics from Stats SA telling you that in 2019, we had the population of 4,592,000. But now in 2024, this increased to 5,361,000. What did it do to the provincial legislature? The MPs from Mpumalanga had to be increased as a result of this. They moved up from 30. Now, that is in 2019. Now in 2024, the MPs for our province have gone up to 51. And that talks to the population of Mpumalanga.
But
Judges
the
remain where they were.
7. I'm saying judges remain at 7.
They remain where they were. You are right, Chief Justice, where we were in 2019, irrespective of this, and we are left to make submission to the Rationalization Committee chaired by the retired Deputy Chief Justice Musaneke. What is going to give or what we will have from there, well, it's anybody's guess. Chief Justice, in conclusion, let me indicate on the 17th of August, 2024, I presented a paper to the NBCSA on service delivery, dispensing justice to the people of Mpumalanga. And when I did this presentation, I did some wider research in respect of our province, and I also did some comparison analysis to the other provinces or division. And when I did this, I was trying to focus on when is the next available date to do trial or to allocate for civil trial for our people in Mpumalanga, the people that were called to serve. And I compared this with other divisions. In Mpumalanga at the time, the next available date for trial, the allocation for trial matters was April 2025. And of these dates, Chief Justice and Commissioners, you can just add 2 more months because this is 2 months back when I did this research. It was April 2025, dates available to allocate for civil trial. In Middleburg, you're talking of February 2025. KZD, that is KwaZulu-Natal, Durban, January 2027. In Pretoria, we were looking at July 2029. Johannesburg, they have a separate role for the RAF matters. And for RAF, you are looking at June 2029. The cases against the Minister of Police in Johannesburg, you are looking at October 2027. And if you add 2 months, you will be even more accurate. While inadequate number of judges seems from this to be a national problem, I think something needs to be done more to the last born of the divisions. I'm talking of Mpumalanga. And with these days, Chief Justice, it cannot be business as usual. When people are involved in a car accident, they are not in good health, they need to claim for those damages and whatever they are entitled to. And they have to get a trial date in court. And they're given the dates that are about 5 years away. How do we expect our people to survive that 5 years with all those injuries sustained from those accidents? By the time these trials come, counsel will be simply telling us they are no longer proceeding because their clients are normal. So something needs to be done if we're serious about service delivery. As public officers, we took the same oath to see to it that we are able to help our people. And of course, I need not just zoom into this and leave it as a problem. There are possible solutions that I propose to the Judge President, and she is embracing to all these suggestions. Amongst them, I know very well we communicated. She is in talk with the bars, the legal practitioners, to get to what seems to be working. In Mpumalanga, I'm talking about getting the practitioner avail themselves to serve on pro bono basis for a week or maybe 2 weeks. And I so much wish, JP, I could even talk to possible solutions when it comes to the awaiting trial or long matters, but I think
we have those.
I'm happy, Chief Justice. I'll leave it at that. I think I should stop here. Thank you.
Yeah. You have left me so despondent, and I'm speaking for my other colleagues as well, no doubt. You've just reminded us of the quagmire the judiciary finds itself in, and we are told there is no money because all these things require money to solve. And we're told there's no money and the judiciary is not exempted from austerity measures. So I don't know what we are supposed to do. But thank you so much for this presentation.
Thank you, Chief Justice. In fact, on what you just said, Chief Justice, you would be happy to say that of the proposals that I make, there is one proposal, perhaps I should sell this idea with the Chief Justice too, rather than my JP.
Your JP.
It is in the long term. And of course, it will require even the political will, because in long term, I propose that the Office of Chief Justice should be allocated budget. That is one of my proposals.
Mm-hmm. It's part of what we want is for our institutional independence, Judge Ratshibvumo.
I agree.
Yeah. Colleagues, it's 2:25. Should we take a lunch break, short lunch break, then come back and put questions to the candidate? Okay. We'll come back at...
I think, Chief Justice, the candidate must be told he's not allowed to eat.
Why? Why do you want to starve him? We'll come back at 2:55.
Thank you, CJ. I think I'm going to raise the 4 questions that I had for Judge Mank as well, but you have addressed some of them. I want to inquire from you, because I see from the form you stated you don't have any reserved judgments. Is there any change in that regard?
No, I do not have a reserved judgment, Judge President. I didn't have when I completed the form. Even now, all my judgments are delivered.
Okay, and the partly hate matters? Is it still the same? You don't have any?
I do not have any parted matters. Whenever I'm allocated matters in the criminal trial, I do the running of the roll till the end of the trial.
Okay. Briefly, can you just explain to us what's your understanding of the role of the DJP?
The role of the DJP Judge President is to support the Judge President in the division. The DJP doesn't come with his own vision. Otherwise, we're going to have two visions in the division, and that may not give a good picture to the public that we're called to serve. That, however, doesn't mean a DJP should not have ideas. But when you have ideas, like I try to highlight, you sell that to your JP, and once they're accepted, it's not for you to sit by your legal corner and say, that's my idea. It becomes the vision of the JP, and all the judges in the division have to embrace it as their vision. So the role of the DJP is to support the Judge President, to support her in terms of ideas, to do all the tasks allocated to him or her by the Judge President, and everything else that the Judge President may have to do when she is not in.
I'm going to ask this question because I asked earlier on, but you dealt with it partly. It's about any challenges that you have identified so far in the division and in any possible solutions that you have in mind. But if you have already covered all of them, you don't have to repeat yourself, please. Maybe you can just, if you have dealt with all of them, you can just name them, but please don't go into detail.
I will not go to details, JP. I have dealt with so much, and these slides, I was just looking, realizing at the time I stopped, I was in slide number 11, and they go to slide number 41. So that means there is
No,
quite
don't go there, please.
No, JP, I wanted to just say one challenge which I think it's important, and I will not go to the slides. Does the challenge involving the clogging of the role, that is having so many criminal matters not proceeding on trial, you will realize that in our division we also have challenges of colleagues, especially who will be sitting in the criminal role, having matters not getting finalized. But that doesn't get limited to to the High Court. It's a problem that flows down to the regional court, to the district court, that cases are not being finalized. And my proposed solution from these slides, you will realize, is to the effect that, and these I'm already trying to implement it in the PEEC meetings, that every judicial officer, every judge, every magistrate, before you postpone your criminal trials, criminal matters for trial, there has to be a pre-trial judicial case management of that matter. Before it is set down, inquire from the parties who are involved, both the public prosecutor and the defense practitioners. Find out how many witnesses are going to be called in this matter. How is the accused going to plead? Do you have defense witnesses that you need the state to help you to bring to court? Okay. In what language is the accused going to conduct the trial? Because when you don't deal with this, you will be faced with this on the date of trial. No wonder these trials collapse. The accused speaks the language that we didn't prepare. We don't have the in-house interpreter. If you know all that, and the defense practitioner informs you as a judicial officer that I have been properly instructed, fully instructed for trial, it's highly unlikely that when you are supposed to start with the trial, you hear there's a reason for us not to proceed. And indeed, serious steps may have to be taken when you have done that kind of pre-trial judicial case management, and when comes the date of trial, you find a person is telling you, I've not been paid to do this.
Thank you.
Sure.
Thank you, Chief Justice.
Thank you, JP. Do you have questions for the candidate, Premier?
Yeah, thanks, CJ, once more. I prepared 3 questions for the 2 candidates. I will continue to ask you these 3 questions because I don't want to ask you different questions from the ones that I asked the first candidate. But don't repeat yourself. I will request you that If there is something that you think that you did not bring to the attention of the commission, and then you may use this opportunity to bring that to our attention. Mpumalanga is a rural province, and access to justice is still a problem in certain areas. Why? And how do you think that we can deal with this challenge?
Thank you so much, Premier. It's very tempting for me to say I refer to the above, because I think I dealt with that aspect fully when I was talking about the establishment of circuit courts, of which you are not going to have circuit courts unless we have
don't
extra
repeat
judges.
yourself. If there is something that you think that you want to bring to the attention of the commission, if you have responded, then it's fine.
No, I don't think there's anything more than what I've already indicated earlier.
Assistance to JP also. I know that you have indicating here the role of DJP. So also, again, I want to know your assistance. Again, as I've indicated, you have diluted my question, but I continue to ask you because I don't want to create that impression that I have different questions for two candidates, but still you are restricted, that only deal with issues that you did not bring to the attention of the commission.
Premier, I think after your questions, you're going to pass me with cum laude because I'm a good student. I've dealt with that. I have nothing more to add.
And just in case you were not finished with the document, this is his vision. It's this thick, Premier.
Yeah.
So all these questions you're asking are covered in this document.
Yeah, they're there. But the last one that I want to deal with is the conviction rate of GBVF, that in the province is very low. What is the reason, and how do you think that we can be able to deal with this challenge?
Right. There are various reasons that you will have the conviction rate low. In our province in particular, and I think this, although it's a national issue, but it's very unique also to our province. We have a tendency of cases that are set down to proceed on trial. You set the judge and everybody, defense, prosecutor, they are ready. The matter is set down to proceed for 2 weeks. Come the date of trial, you find the matter is not proceeding. And I'm not talking about judicial case management issues that I highlighted earlier, but simply because the witnesses have vanished or witnesses are scared. They no longer want to give evidence. And I'm talking, I don't want to mention names of anybody, but some of the prominent cases that should have proceeded on trial right in our provinces, they couldn't proceed for that reason. Witnesses getting scared or getting intimidated. So surely there has to be something to be done to protect the witnesses, to assure the witnesses that they need to avail themselves. Because at the end of the day, you have case, it makes headlines, but it does not even go on trial. So the aspect of protection of witnesses needs to be enhanced. The public needs to be assured that if they give evidence in court, they are not going to be victimized in any manner. There may be other further solutions to this. For example, interaction with the public, something that I personally, I'm in the forefront of doing that. Thanks to UNISA Chance to Advance, we are trying to train the community to know that you don't have to beat a woman for you to be a man. And we are having some successes here and there, but we may need some assistance from other corners. Thank you. Thank you, Honorable Premier.
CJ, thanks.
Thank you, Premier. Questions, Commissioner Balwe?
Thank you, Chief Justice. Good afternoon, Judge.
Good afternoon, Commissioner.
Yes, Judge, you received from the JSC last night a document in which certain concerns are raised by people that allege that they appeared before you in a matter of eviction. Do you confirm you received that document?
I did, I confirm.
Yes, and is the matter familiar from the names of the people that are in that list?
Not from the names, it wasn't familiar. And unfortunately, at the time I received the complaint, the court had already closed for one to be able to draw the file and the like. However, from the notes that I prepared that I have on my laptop, I was able to refresh my memory and I remembered what it is.
Okay. So from the, as you would have seen, I think the most important part that relates to you is the allegation that you granted eviction orders without giving any consideration to alternative accommodation, and the class of people that are affected by the eviction are described to include old people, disabled people, and children. We haven't had sight, we don't have sight of the judgment, so it wasn't attached and it wasn't attached to this document. Was the order attached? Okay, all right. So the question really that's important for your purposes is whether, and if not, why not, you did not give consideration and deal with the question of alternative accommodation. In fact, I've just been given a copy of the order, and on the order itself, you don't say anything about arrangements for alternative accommodation for these people that were being evicted, and I see that the municipality was a second respondent. Do you want to speak to us about that? Because what is being conveyed is you don't seem to be aware of the obligation and duty of a court in dealing with eviction matters to look into the question and the interests of affected people as it comes to alternative accommodation.
Thank you so much, Commissioner. Like I indicated, I did not have the privilege to go through the file to refresh my memory regarding what could be in the affidavit in the matter. So I was able to refresh my memory only in respect of the notes that I have. Commissioner, what I can say is the following. I noticed that matter, it's a live matter in the sense that it is still pending before our courts. And there is still an opportunity that the matter could be on appeal any moment. And seated from where I am, I wouldn't want to victimize or jeopardize the appeal process that could be on the way, or it could also be a rescission by giving so much, saying what could be criticism for or against what is alleged in the documents that were made available to me. But it suffices for me to say the following from where I am. Any suggestion that I did not have sympathy to the cause of the respondents in this matter, it's not true. Commissioner, ours, it's not an easy job. And I believe I speak on behalf of so many judges when I say that some of the orders that we make as judicial officers, I can tell you they are penned down with tears. It is not an easy thing, and if I was to try and move away from this matter but talk to the general approach in cases that could be...
Judge, please allow me to interrupt you. I don't mean to be rude. I think this is capable of a response that deals directly with this matter without going to the difficulties that the bench and the emotional issues that get attached to making decisions. It's simply this. This is an application for eviction. On the face of the order, you do not deal with the question of alternative accommodation. You issue an order that these people should be evicted. The second respondent in the matter is a municipality. And certainly on the order, you don't seem to have taken into account the question and the obligation of a municipality and our law, what our law says about that, to make sure that people affected have alternative accommodation. Your order is silent on that. That's one. So that's the first issue. The second issue that you would have seen on this document is you ordered that the evictees must pay costs of the application. And the criticism there is you seem to have disregarded the judgment of J.P. Mlambo, where he spoke about these duplicated applications which are cut and paste and orders granted in respect of all those duplicated applications. So there's the two criticisms that are rising from this. And I think you can answer, it's possible to deal with it without affecting the appeal. You've made a decision, your judgment is final, so it has nothing to do with what happens on appeal. And the simple question is, you don't seem to have had any concern for the alternative accommodation needs of the evictees. And of course, the cost order.
Thank you so much, Commissioner. And thank you. Chief Justice, I thought I was trying to respond to that, giving the background of my response. If you will allow me, I will carry on from there, and I will be answering exactly what you asked me, Commissioner. I am saying, and I want to repeat, ours, it's not an easy task. And a person may easily conclude that when you give a judgment, you were insensitive to the needs of the parties before you. And I'm saying some of the judgments or the orders that we make are made or written with tears or penned down with tears. The reason why I'm saying that is, when I sit down and write a judgment or make an order, just as we took an oath, you do that having looked at the facts before you, delivering justice subjects to the law and the Constitution. And I'm saying, if anything in the matter looks like I may not have given any such consideration, that is not the case. I did give serious consideration to those aspects, all the issues that were before me. In fact, you may think this matter could be like an ordinary matter as you're talking about. This was presented to me as a matter involving building hijacking, and the buildings having been hijacked by the parties, and if my memory serves me well, the response to the founding affidavit by the respondents were to the effect that, yes, we took over the building, but the building was abandoned, and there were criminals who were taking over those buildings. So taking over of the building was more of preventing the criminals occupying those buildings. So that is how the matter was presented to me. And yes, in many matters involving evictions, it's very rare that you'll find that I make an order regarding the cost, that the respondent should pay the cost when they're being evicted. But after considering everything that was in that file, the allegations being made against the respondents, and whatever the respondent said in return, which unfortunately I don't have the privilege to look into, I reached the conclusion that I reached in respect of the eviction. And to say that I may not have applied anything that you are saying regarding the constitutional requirement, it's not so. I had the view, so you will see that one of the respondents in the matter is the municipality. I had the privilege to hear what the municipality was saying. And if my memory serves me well, like many other cases that I would have a view from the municipality, they would be saying under oath, we do not have an alternative accommodation for these respondents. So I did have the views from the municipality. They had their say in the matter, and given that, you will see that the applicant wanted eviction within a certain period. And in considering what is just and equitable decision in the matter, I decided to extend or give a period of at least 90 days as an allowance to allow the respondent to vacate the premises. Thank you.
Maybe just to make a correction, you gave them 90 days, yes, you're correct.
Thank you.
Yes, I do want to follow up on this because I think, sometimes Judge Ratshibvumo, the answer generates more problems. Are you saying that your understanding of PI is that if the cause of the unlawfulness in the occupation is a building hijacking, and the municipality says they have no alternative accommodation, you are entitled to disregard Section 4.7 of PI?
No, I'm not saying that. What I am saying is I had considered what the municipality had said in the matter regarding this, and I considered the version by the respondents, which unfortunately, I don't recall everything that was said in this complaint. The affidavits, unfortunately, are not before me. At the time, I was of a view that decision was a just and equitable one.
I mean, I can understand an answer that says, look, I got this last night, I want to go through the file. I understand that, that's perfectly legitimate. But I can't reconcile myself with an answer that says, no, I know everything. These were building hijackers, therefore they were entitled to be evicted together with their children, with disabled people, with child-headed homes, for as long as they were building hijackers. Now that, I'm finding it extremely hard, because that is the very same argument that is made by every landowner in the city of Johannesburg. And it has been the case since 2010. And every time the Constitutional Court says, well, that is just the reason for the unlawfulness, but the obligation in the statute is clear, there must be alternative accommodation, sometimes emergency alternative accommodation. But if your answer is, no, I don't know enough about this, and it's not fair, that's fine.
No, Commissioner, I think you did get me in the part of your question. I am saying I did not have access to the affidavit when I looked at the complaint. It came only last night.
That's enough.
When I talked about the hijacking, I was just giving a background on how it came.
That's enough to say I don't have enough information. I'm
Thank
worried
you.
about the justification you are giving for the order.
Thank you. I agree with that.
Thank you, CJ. Mine is not a follow-up, it's just on a separate issue arising from, good afternoon, Justice Ratshibvumo.
Good afternoon, President Mpumalanga.
How are you?
I'm doing fine. How are you?
I'm fine, thank you. You mentioned both in your written vision as well as in your oral outline, you mentioned the study tour to Washington that was led by the former Deputy Chief Justice Moseneke.
Yes.
Yes, I confirm your participation in that because I also was part of the delegation, as you mentioned.
Sure, I remember that.
Yes,
Thank you.
I don't know whether you recall this, but what I remember is that towards the end of the tour, you volunteered to write a report. And I was quite impressed to see that on the last day of the tour, you were busy drafting the report already and circulated it within a week. Is that correct?
No, that's correct. Thank you for that, yes.
And that the report was quite comprehensive in that you even made recommendations.
I did make recommendation. You are right, President.
Yes, and that was a few years before the COVID-19 pandemic. And I recall that during the pandemic, you called me, phoned me, and were excited to say that you are now happy to see that some of the recommendations that you made to JIT, because you were a member, are now being implemented.
No, definitely. I was on the forefront of that, and I am glad you remember that I played a little role. And indeed, when 2020 came about, I smiled when I saw that those recommendations were working out to see to it that justice is still delivered to the people, irrespective of the lockdowns. Thank you, President.
Yes, thank you. I just thought I should mention that because I think it also talks to your strong ethic in terms of, first of all, taking the initiative to prepare the report, and then secondly, circulating it very quickly after the tour. Thank you, Justice Ratshibvumo. Thank you, CJ.
Thank you, Madam
Thank you,
President.
Questions, colleagues? Okay, we've reached the end of your interview, Judge Ratshibvumo. Thank you for making yourself available for this position. You're excused, sir.
Thank you so much, Chief Justice. And being the last candidate here, some of those who came here told me you are going to close the session there with vote of thanks. I believe I speak on behalf of all the candidates who came to sit on this hot seat when I say thank you so much, Chief Justice, and thank you to all the commissioners.
It is our pleasure. Thank you, Judge.